Hello and welcome to the Advanced Resolution Management podcast and Lawcast with me, Abbas Kazerounian, your host. Today we have a one-on-one with none other than Justice Nancy Becker. Hello, Nancy, and thank you very much for being here.
My pleasure, Abbas.
We're actually going to be dealing with a pretty intricate and complicated subject today, which is really our mediations and more specifically remote mediations, confidential in the way that we perceive them to be confidential as litigants and as neutrals. And the reason, you're specifically being asked to be here today, Nancy, because for a lot of our viewers and listeners, if you've never had the privilege of being in a room with Nancy Becker, she is almost inevitably every single time the smartest person in the room. So it's really, really important that you pay attention to what this lady says, because I always learn something with her. So Nancy, let's get right into it. Our mediations are really, really confidential as we perceive them. So I think we both read this article that came out on Law 360, which kind of laid out some very, very interesting points. And it certainly took me back a little bit, because I always perceived as a litigant that I'm in a secure space. Everything that we do is confidential, because one of the things that, most ADR providers have the protocol that you sign the confidentiality agreement and you go in and everything is under this, sacred, sacrosanct, umbrella of privilege. But that's really not the case, though, is it?
Well, it's generally the case, yes. But the court, in a court can always issue an order at some point in time that says that what took place in the mediation can be disclosed by court order. Now, do most courts do that? I did read the article. I tend to differ from the author. Certainly, he quoted examples of courts that have done that. But it has been my experience, both federally and state court, that if there is a confidentiality agreement, that's a contract. We enforce contracts. That's the rule generally in courts. And they'll look at the local court rules. Is this a private mediation? Is this a court annex mediation? What rules apply? What state statutes apply? So I would say that for the most part, confidentiality does apply. And that's the rule.
Sure. I think
to exceptions in an individual case.
I totally agree with you. I think the general rule of applicability is, that there is confidentiality and we've all agreed to it per contract. Now, the examples that were given in the article, there's really two main hypotheticals where this can really be an issue, especially specifically with remote mediations. And I think this is obviously relevant because 99% of mediations during COVID right now are remote. I think the first example and hypothetical we can have, which is the most common one, is you have a mediation in state A, let's say Nevada, right? You have the mediation because the lawsuit is venued there and, everything is really happening there. But a participant to that litigation, maybe it's an adjuster, maybe it's an attorney proactively chased into the case, is, let's say, in New York, because that seems to be the least protective state from what I'm reading right now. So let's say they're in New York. And AIG is a big insurance company based out of New York. That would make sense. So let's say they're out there. They're participating and they've signed a confidentiality agreement, which is, at least at ARM, that's our protocol. You don't participate in the mediation unless you've signed the confidentiality agreement. Right. However, you come to terms, you do a term sheet, everything is great, and Justice Becker settles the case. Phenomenal. But then the parties can't consummate that understanding to a final document. And there is some kind of mix-up. At that point, is there a choice of law conflict between New York and Nevada? If you're trying to, let's say, subpoena or do discovery on a presentation made by the New York participant?
So we're assuming for this hypothetical that the actual lawsuit or cause of action will be in Nevada. And the answer to that is that the Nevada statute is very strong, as are the Nevada rules and the Nevada case law. mediations, settlement conferences are not subject to discovery and are not to be used within a litigation context. So to the extent that someone wants to, a third party might want to compel it, court's going to say no. There's going to be, by one party or the other, a motion presumably to compel the settlement as a good faith settlement. Under Nevada law, you don't need a final legal document with all the nice, I's dotted, T's crossed. If you've got a term sheet and it's got all the material terms in it, then it's enforceable. So the Nevada courts have said what occurred at the mediation is irrelevant. What's the term sheet say? Right. And they'll determine on that basis. And then let's suppose a court says, you know what? The parties after the fact realized there was a key feature that nobody talked about. So I'm going to say, and no one let me as the mediator know. The parties just sort of, it went over somebody's head and they didn't think about it. All right, so a court may not enforce that. So now what happens? If you proceed with litigation, and I'm going to do my best to get back in there and get it settled, but let's say I can't. Then somebody may want to say, well, we want to subpoena either myself or we just want to do discovery about what actually took place. Well, the Nevada statute says you can't do that, and the Nevada courts have enforced it. And the federal courts in Nevada have said, look, this was done under Nevada law. That's where the mediation took place. That's where the litigation is. We're going to apply Nevada law on this. We're not going to apply our looser standard under federal law. But there's never any guarantee, because you could obviously get a particular judge who, for whatever reason, wants to compel it. And, then you're faced with do I want to take a writ? Do I want to appeal it? What do I want to do? If it's a federal court, do I want to get mired in the Ninth Circuit dealing with all of this? So, sure. But for Nevada, yeah, there wouldn't be a conflict of law. But let's suppose that now you were mediating in Nevada, but the actual situs, the jurisdiction is New York.
The inverse of what we're talking about. So since you're already on a roll, carry on. I'm not going to interrupt you. You're doing really good. So
in New York, New York's going to say, no, we're going to apply New York law because it's New York jurisdiction. And while we understand you mediated in Nevada, we think that's more of a convenience, right? But the New York courts, as much as the New York statutes allow for discovery of settlement negotiations, and a mediation would be that. They also have case law that talks about, well, this is a contractual provision. So depending upon how strong that contractual provision is, the New York court may say, even under New York law, which is more liberal about these things than Nevada, we're not going to allow this because that's what you agreed to. And New York is very strong about a contract is a contract is a contract. And as long as it's clear, so, at ARM, we try to make our mediation contracts, not a 5-page, legal document, but something that hopefully will hold up in some of these jurisdictions. And that's one of the things that we try to look at. Is it always going to work? Maybe not, but.
And I think you're absolutely right there. I mean, like the choice of law and potentially the forum selection that may be in the contract is usually enforceable, but courts always have their inherent power or public policy reasons that where they may want to sort of make it unenforceable or circumvent that contractual clause. And I think there was a very interesting case that's very analogous to pretty much what you were saying, but a real life case called Larson versus Larson, which was a Wyoming venued case. This is one of the cases that was cited in the article that I mentioned. And this was like a sibling rivalry lawsuit in Wyoming, but they met face to face and mediated in Colorado. And the contractual provision that they actually all signed in Colorado was all communications, whether oral or written, made in the course of the mediation process are confidential by this agreement and the Colorado Dispute Resolution Act. So, so to a certain degree, they were adhering to the choice of law or that particular act in Colorado, and yet the 10th Circuit went against that as a matter of public policy when it ultimately got to the appellate stage after the magistrate compelled the discovery. So but I still tend to, in my gut, agree with what you're saying. Most courts are gonna tend to follow the contract because that's the intent of the parties. But I think what the listeners and the viewers should be obviously like privy to is that the court can still do what they want to because there's legal avenues to get around these things.
Correct. And that's always a risk. I think the key to mediation and what people really focus on, first of all, no mediator should promise that nothing will ever be released. You know, that's not the kind of conversation a mediator should be talking about. I think most people are more concerned that what they say to the mediator is not going to be disclosed to the other side. And certainly that's what the mediator needs to discuss. I think that and there are even circumstances in states that have strong laws. Suppose that there are procedures, as you know, Abbas, in many states for what we call in Nevada an offer of judgment. It's called different things in federal court or other state, but it's essentially I agree to let judgment be entered against me, or I agree to pay you X amount of money. You have so many days the other side to respond. And if you don't, it triggers the potential for attorney's fees. And if you don't have some other basis for attorney's fees, contractual, statutory. And so there have been some courts that have said, look, in that context, so now we've the mediation, we couldn't get it settled. They've gone on to do their litigation. One side or the other wins, but they don't win enough that they're able to beat that offer. And so now the attorney's fees can be triggered. And there are some courts who have said, all right, generally what you do in that response, whether you're rejecting it or is based on a reasonable standard. And it's usually the reasonableness of what you knew about the case at the time that you rejected it. So there are some courts who have said, look, we'll allow what took place at the mediation solely for that limited purpose of determining whether it's reasonable, but we're not going to allow you to subpoena the mediator to come and do that. You're going to have to prove it up through the documents that were presented at the mediation and what the parties knew at that time, and not so much what was conveyed back and forth by a mediator. So that has occurred in cases. But again, I mean, if you're one of the parties involved, one can always argue that at least one side has waived it because they're asserting it in that context. So that, I think, is more likely to occur than what happened in the Wyoming case. But
I think the issue that you just raised is a very good one because I regularly do this. So I think with the context you're talking about is maybe under Federal Rule 68, Federal Rule of Civil Procedure, Rule 68, which is an offer of judgment.
Correct.
And in a fee shifting statute, I mean, as a litigant, what I do is in practice, as course of business, is I regularly paper the file where I'm making offers to settle the case throughout the duration of the litigation. Hey, are you sure you don't want to settle? Here's an offer from my client. Here's an offer from my client. Then they send the offer of judgment. I file the judgment with the court, and then there's this fee dispute. They're going to argue that my fees are unreasonable because if I'm the plaintiff, And then I, at that point, will introduce this trail of paperwork, not for like, you know, to try necessarily introduce what was being said in the negotiations, but the fact that they had ample opportunities to settle, and now they can't be complaining about the fees. And there's always objections under Rule 408, which is always usually well, I can't say always, but 98% of the time, the judges overrule that objection. They're saying it's not coming in for what transpired, but the reasonableness factor. And I think a lot of litigants lose that. And so, and 408, you know, also covers mediations, which is what you're talking about. So you're 100% right that I don't think anyone can represent that a mediation fully 100% confidential, because there are certain elements that are triggered by other procedural kind of mechanisms in our litigation track that potentially can bring that in.
Right. And honestly, I don't think most people who participate in a mediation are worried about that downstream aspect, where one side wants to use something that occurred in the mediation against the other. It's the scarier one is those cases that were cited in the article, where a third party is allowed to invade into what took place at the mediation. And I certainly must say that I too was a bit taken back by that, because I have never seen a court do that, allow a third party to do discovery. But the facts and circumstances in those cases were very unique. And so I just don't see that as the bigger thing. I think most people just want to make sure that, listen, when people send me a mediation brief, most of the time they don't specifically say what's been exchanged in discovery and what isn't. Well, if you don't tell me, it's logical to assume that all of this has been through discovery. But I never do that. I always ask them, okay, you got to tell me, because you didn't put it in your brief. Are these exhibits everything that you attached? Have you shared with the other side? You know, can I discuss them with the other side? And I think that's where your biggest issues, where if you're a mediator, you've got to really make sure they understand their duty in terms of confidentiality, in making sure that they're advising the mediator as to what is still confidential, because lots of attorneys, that's one of the areas where I've seen that they don't, or areas where I've seen in mediation resolution disputes against a mediator, where a mediator may have made a mistake or didn't get that clarified. So I think most people, that's where they're really concerned about is, you know, I have what I think is the smoking gun, and for whatever reason, I don't want the other side to know the smoking gun is there. Why you don't is up to you. That's your strategy. I don't know why you're telling me about the smoking gun if you're not going to tell the other side. But hey, sometimes that's people's strategies, and that's what I think most people are looking at from it. And I think in that context, I think mediations are very confidential, assuming that you have a competent mediator, somebody who understands all of that. So, and while I thank you very much for your kind words at the beginning, but I certainly have never thought of myself as the smartest person in the room. I think it just, you know, when you've been doing stuff like this for 30 years, some things become ingrained in you, and you always make sure you have your checklist and stuff. So to protect confidentiality.
If you thought you're the smartest person in the room, you probably would not. People that generally think they are not. That's another reason why you are. But that's a whole different issue. But I think, you know, a lot of people go into mediation very blasé, because I genuinely believe there's an art to it. I believe that it's a whole skill set. And it's got its own, not a great amount, but it's got a body of law that we should kind of delve into. And I actually did know one of the things that were pointed out in the article, and I've asked a lot of colleagues to read that article and just give me comments back. And a lot of people came back and said, I had no idea there's such a thing as a settlement privilege. Because, and it is an outlier law, admittedly, and because I think the Sixth Circuit in the Goodyear case adopted the settlement privilege, which has actually not been adopted by the majority of courts in other jurisdictions. But it's something that I was privy to because, I pride myself in knowing a lot about mediation and the whole thing. But I think one of the takeaways from this particular episode, which is really fascinating for me, and a lot of the things you've laid out, it's not common knowledge. And B, I think it's really important to do the legal research and really be well informed about mediations generally, but that type of case, the jurisdictions involved, and the body of case law that follows with it. Because, mediations is not just about the snacks and carrying numbers. It's so much more than that. And I think if somebody watches this episode that is not well educated on mediations, they'll probably learn a lot. And I hope that they go away and do some additional research, because this exemplifies why mediation is not a simple thing. And it's much more complex, both in substance and procedure and skill set, than a lot of people give it credit for.
I think that's true, because it all depends on, where are you? Where's the mediation conducted? Where's the lawsuit going to be, or the arbitration, if that's where we're going next? Are you going to be in federal court? Are you going to be in state court? Nevada has very strong statutes and rules about settlement conference privilege, though it's not necessarily phrased that way, but it does end up in the privileges section of the statute. And Nevada has a lot of court annexed settlement conferences where they're run under the auspices of the court rules. And that, again, confidentiality is a big part of that. But I know that that's often not the case in other states. And so then you're back to, what does your contract say? And contract enforceability and conflict of laws. And that's where it gets complex. And I agree. I think that any lawyer or in the event that a party is representing themselves, they really need to understand so that they know that their expectations will be realistic in terms of what's going to govern. And that's, I agree, it isn't easy. And it has a lot more to do with, for example, is your down and dirty term sheet enforceable, right? If you're in a jurisdiction that says no, until it gets to a final document, it's not enforceable. Well, now you have to spend a lot more time to make sure when you leave that mediation, you got to have something that's a lot tighter. Or both parties have to recognize the risk involved. And it doesn't come up, I'm sure, as often, but when you're talking about complex litigation, class actions, where you got multiple jurisdictions, you just can't kind of say, oh, we're all going to get in a room together and talk and come to a meeting of the minds. It's going to be a lot more detailed than that. So,
and especially with somewhere like Vegas, especially with ARM, is kind of a destination ADR center where people from different jurisdictions come. By the way, kind of footnote, you settled for about $5 million or so, just got finally approved class action in Florida. It happened orally yesterday, and today the order came out. So,
but that's a good example, right?
Exactly.
Without getting into any details, you had class actions that were pending in 2 different jurisdictions, and you had to decide, where are we going to go to approve the class and the settlement? Are we going to go to jurisdiction A, jurisdiction B? What are the benefits? What are the downsides?
Yeah.
I had a mediation where you got parties who live in one state, parties live in another state. and they're trying to figure out what are the tax consequences. So as part of the mediation, you're trying to determine, well, you know, if one side lives in Nevada that has no state income tax, and one side lives in California or New York or that has a lot of taxes, you know, how you exchange property, how you settle, where you go with it, it gets, so you have to start thinking, well, wait a minute, will New York apply Nevada law to this, or well, you know,
and $100 says in that pickle there, nobody thought about, well, is there a conflict of law difference between the confidentiality privileges of, like, you know, mediation from these different jurisdictions?
Exactly. Nobody was thinking of it from that way, but we did have a number of very competent lawyers, and you know, the lawyers in the one jurisdiction are, okay, wait, that sounds like a reasonable settlement, but wait a minute, we got to pass it by the tax experts, and the other lawyers are doing the same thing. And okay, well, then we're going to want a conflict of law provision in the settlement that's separate from the conflict of law over here. And, you know, and part of that is part of, you know, you have people who are on video, on the virtual, but you also have attorneys that are right there in front of you, properly masked and social distancing. And, you know, it's, so those were the kind of the things, because the mediation agreement did talk about the conflict of law from that standpoint of what's confidential and so forth. But
sure.
But, you know, is New York going to enforce that? And if not, what are we going to do here? And
I think, you know, as kind of like the last point as to this topic, before we move, change gears a little bit, is I find it interesting that there's no federal, uniform federal law on, because like 408 is not a privilege, and there's no federal mediation privilege. I mean, there's the Uniform Mediation Act, which was adopted by, I think, 10, 11 states. And then there's a few states like Nevada and California that have more protective rights than the Uniform Act. But there's all this disparity in law. And where you're talking about so much fluidity in litigation from state to state, maybe there's a call for some overarching federal standard that I think we should be bound by, rather than, you know, the gray area and, you know, the I guess the issue of not knowing, because even if you contract to it, as we've discussed, a court can still go around it. But if you have a uniform law, the law is the law, so it's going to make it a little bit easier.
You know, I do think, because I was quite surprised to see how loose it was federally, and I thought to myself, well, what judge doesn't want to promote settlements? And how is this public policy promoting the concept of settlements? So I was absolutely taken aback by this concept of, well, public policy says this shouldn't be confidential. And I'm thinking, do you want to settle cases? Do you want to encourage parties? I honestly think that that's something that the federal courts really need to look at. They're always saying, well, depending on what jurisdiction you're in, that they have too many cases.
Yeah.
And certainly that may be why some state courts have enacted it, because they're trying to strengthen the confidence of the litigants in the settlement proceedings. You know, what I say won't be used against me, and in litigation.
Sure.
So I know that's the primary public policy behind Nevada's, and I suspect California's as well. So
great. Well, I mean, it is honestly really fascinating. But let's change gears. I mean, like in this kind of same vein of doing these mediations remotely, let's talk about like kind of the protocols we have at ARM and like what the industry is doing. I've done some mediations with other vendors, and the general rule of like that, they're all tending to use Zoom rather than other platforms like Skype or BlueJeans, which is what we use at ARM. And And what happens, which I find interesting, is we go into a general caucus where everybody's there, the defense, the parties, the mediator, and then there's breakout rooms. Whereas the way we do it at ARM, and obviously I'm biased, and I would say I prefer it, but I think it kind of is more traditional in concept, which is everybody has their own 9-digit ID code and room. And so when you're going into the mediation, as let's say the plaintiff or the defendant, you're only going in there with your client and nobody else. And so you're not forced into this joint caucus and joint session, which is generally not how they go down in person. You go into your own rooms.
Right.
And then you have the ability to decide if you want to have a joint session with the mediator later on. And what I like about it is that the mediator has to literally come out of the room and then log back in with the specific identification to go into the other room. So there's no human error. You're not talking to the wrong people. You know exactly what's going on. But most importantly for me is that it kind of tries to keep true to the normal notions of mediation practice as if there was no COVID, in contrast to what other vendors are doing. And have you found that that's been helping at all, or no? Yes.
No, I think it does help. When people, it's no different than if they're in a physical room, and that's very helpful to keep you focused. And it allows them to talk and interact with one another when you're not in the room. And that's exactly what goes on in a mediation, right? You want to use your time wisely. So I've just been in a room. I've pointed out some of the pros and cons that people need to think about in terms of the facts and the circumstances. I leave the room. They need to talk about that, and they need to know that when they're talking about it, nobody else is listening in. So the technology has to be such that you feel confident that that room is secure, and that you can see if someone else pops up. The other day there was some technical difficulties, and somebody said, "Who's this?" And I said, "I don't think it's one of our staff, because none of our staff have that name." Well, I went and I checked. Actually, it was one of our staff, because this is the code name they use to indicate we're on the line because we're having technical difficulties. So we knew they were muted, and we knew that there was no camera, so they weren't listening to what was said. But the client said, okay, and we didn't talk about certain things while they were working out the technical difficulty, because you always have, technology is what it is. You can't always guarantee it's going to work the way you want to. But what made the client feel good was that they knew immediately that there was someone in that room who wasn't part of their group.
Right.
And so that, made them feel much better about the whole process, and the way that it works. So I like the way that we do it. I'm not going to endorse any particular vendor, because that's not something I can do. But I always want to make sure that it works much better if whatever device you're using allows people to start out in their own rooms. And then if I want to bring them together, I can do that, because there are times when, as a mediator, I want to talk to people outside of the client's presence, or when the attorneys want to. So, I like the way that we've set it up. And I have used other systems, and I think our system works best in a mediation context.
Well, that's good. I mean, there was there was serious thought giving into why we did choose Blue Jeans over other platforms, and I think that the four main reasons that really went into my mind was that it's HIPAA compliant. I like the protections that it gives on security in comparison to its competitors. It's HD video, so it's very good, nice and clear as long as you've got a good internet connection. And also, I think one of the major factors is that the 8th Judicial District courts in Nevada use it as well. So there's some consistency there. But it's more. what I was getting in there was more the protocol rather than the technology. But there was definitive thought going into why we use the technology that we use. And I know that us lawyers, we're not good with change, and we're not generally good with technology. So like, I understand that, like, people are having issues, and I'm going to ask our producer, Zach, for when this is published, to put in the YouTube channel here. We have a YouTube channel that gives step-by-step instructions on how to use the Blue Jeans technology if you're ever stuck or in preparation for coming to a mediation with us. So it makes it easier, and it's going to be right there for you guys to check it out whenever you're ready, if you want to. With that said, Justice Becker, I really, really appreciate your time. I think this has been a really, really informative and educational episode, because most of our viewers and listeners are lawyers and litigants, and I think I've learned a lot today and in preparation for today's podcast. So thank you so much for your time. And if anybody's interested in using Justice Becker, and I highly recommend it, available through ARM, go to www.armadr.com. You can see details for her case manager. Thank you very much, Nancy. Appreciate it.
Thank you for asking. It's been a fun discussion.